Welcome to This Week in Education Law School Administrator's Guide, Episode 13. Today I focus on a case that is relevant to both education law and administrative law. Administrative law is the body of law that regulates the operation and procedures of government agencies. You can consider administrative law as the body of law about government agencies' decision-making. A good understanding of administrative law can help school administrators follow effective procedures, avoid abusing their power, and make wise decisions by striking a balance between conflicting forces, individual rights, and public interests. This case is about a school district's failure to follow state regulations on how to use state funds. Poway Unified School District is in San Diego County, California. The school district serves about 36,000 students. In 2014, the school district constructed a new elementary school. The construction project costed $82 million and was funded primarily by special tax funds paid by homeowners in local communities. In 2016, voters approved Proposition 51, which authorized the state to sell billions of dollars in general obligation bonds for education purposes, including school facility projects. In 2019, following the passage of Proposition 51, the school district received reimbursement funds of over $27 million from the state of California, which accounted for part of the elementary school construction costs that was initially funded by special tax bonds paid by homeowners in local communities. The school district held a meeting to determine how this newly acquired state funds of $27 million should be used because the elementary school construction had finished. The school district's associate superintendent presented a report recommending the state funds be allocated 45% to community facilities districts related purposes and 55% to high-priority capital projects. Among the 45% for community facilities district-related purposes, it was then divided in half, with only about $6 million earmarked for retiring local special tax bonds. When a school board member questioned the associate superintendent about this recommendation, the associate superintendent responded that the fund allocation was permitted under the applicable regulations and statutes. The school board voted 4-1 to authorize the recommended allocation of the state funds. The school board member who questioned the associate superintendent on the legality of fund allocation was the single dissenting vote. Two homeowners disagreed with the school district's decision about fund allocation. They argued that, according to regulations, the school district was required to allocate all newly required state funds toward retiring the local bonds unless it could prove there was a savings during construction. But the school district failed to do so. The homeowners brought the school district to court. The trial court ruled in favor of the school district. The homeowners appealed. The Court of Appeals of the State of California concluded the homeowners' arguments had merit and reversed the trial court's judgment. California's education code has a section devoted to school bonds, in which rules for school bond-related legislative schemes are outlined. Chapter 12.5 discusses the Leroy F. Green Act, which was created to govern the allocation of the state funds for school facilities construction. In Article 1, the State Allocation Board is granted authority to adopt regulations for administering the Green Act to determine local districts' eligibility for funds under the Green Act and to appropriation those funds. The State Allocation Board promulgated a regulation which provides that when a school district uses local bond funds to make eligible project expenditures authorized in the Leroy F. Green Act, and state school bond funds are made available to reimburse the state's share of those eligible project expenditures. The reimbursement funds shall be used as follows: A. Toward retiring the local bonds, and or B. Toward uses permitted by the local bond, or C. For any high-priority capital outlay expenditures in the districts as permitted in Section 17070.3, Subdivision C, the Article 1 General Savings Statute. The school district argued that the regulation was ambiguous. The Court of Appeals disagreed. The language in the regulation clearly laid out 3 options for using state reimbursement funds. The list is mandatory, directing the school district shall be limited in how it uses the state funds. The State Allocation Board envisioned the school district would use the funds to retire local bonds or pay for related local bond expenditures. If the school district wanted to use the state funds for other projects, the projects must be approved, as the language "as permitted in" means a restricted exception to the mandated use of state funds. The school district's interpretation of "as permitted in" that all the state's reimbursement funds could be used for expenditures unrelated to the approved project. But the Court of Appeals disagreed, reasoning that the language "as permitted in" is the evidence the State Allocation Board incorporated into the regulation the exact savings requirement imposed by the Green Act. The school district also argued that an audit supervisor at the Office of Public School Construction confirmed in emails that the school district was not required to establish a savings during construction before spending state funds on other priority capital projects. The Court of Appeals noted that, according to the general provisions of the Green Act, the Office of Public School Construction, which is part of the Department of General Services, assisted the State Allocation Board in administering the state facility program. The opinions offered by employees from the Office of Public School Construction were irrelevant. Their opinions did not represent the State Allocation Board's official position on a statutory construction issue. The Court of Appeal concluded that it was a direct violation of several statutory provisions for the school district to receive $27.7 million state funds but allocated only $6 million to build the approved project and spend the rest on whatever capital expenditure it wanted. In this video, I introduce a case relevant to both education law and administrative law. I hope this case can help school administrators have a better understanding of administrative law and make wise decisions by following effective procedures. I'll see you next week in This Week in Education Law, School Administrator's Guide.